Q&A after our panel has made their presentation. At this time, I'm delighted to welcome to the podium Professor Lisa Manheim. Again, thank you.
So thank you, Kelly, and thank you to everyone for coming. So here's the question I have for our panel. Why does it seem like sometimes the president can't get anything done, but other times it seems like the president can do anything he wants, simply with a stroke of the pen? The answer lies in the law of presidential power, and that law is confusing, particularly for those who would like to get involved in the process and have their voices heard. Today's discussion is an attempt to respond to that confusion. It's an effort to help to shed light on the question of presidential power by looking more deeply into the question of what a president can do and what the president cannot do. We hope to demystify these sorts of laws and these sorts of restrictions in an effort to better understand what sort of constraints a president has. And we hope this discussion demonstrates the following point. While it is in fact difficult to understand the legal limits on a president's power, that difficulty exists because the relevant laws are complicated, and not because those laws are random or non-existent. And as a result of these complicated but important restrictions, individuals really can have influence in politics through various forms of civic participation. So we'll be sure to leave a few minutes near the end of the program for questions from the audience. And we'll also be wrapping things up no later than 9 o'clock. Please try to be succinct, no more than a couple sentences. And the reason for that is that we would love to hear from a number of you, and also because we do have a lot to talk about tonight. To that end, let's start with Catherine, who is an expert in presidential powers. Catherine, President Trump has been quite busy in his first 2 weeks in office. Now, things that he says to the news or things that he says on Twitter, that does not have legal effect. But by contrast, when he communicates through what are called executive orders, that does have legal effect, or at least it can. And one big recent example of this is the executive order that President Trump issued on Friday, which imposed the travel ban. So this all leads to the question, Catherine, what is an executive order, and why is the president allowed to issue them?
Sure. Thanks, Lisa. Yes, the president has indeed been very busy signing a number of orders that touch on everything from building a wall, to putting a temporary freeze on regulations in our country, to instituting the travel ban that Lisa just mentioned, to freezing federal hiring. So what is an executive order exactly, Lisa asked? Our government, it's divided into 3 branches, as we know. There's the legislative branch that makes law, there's the judicial branch that interprets the law when deciding cases, and then there's the executive branch that enforces and executes the law. And sitting at the very top of that executive branch is the president. He sits atop a pretty massive executive branch. It has hundreds of federal agencies in it. It has more than 2 million federal employees within it, and about 4,000 of those are political appointees. So at its essence, an executive order is a communication tool. It's a signed document that the president can use to communicate his wishes to those that work underneath him within the executive branch. It's a communication tool to ask officers or to demand that officers do something or stop doing something. At its heart, that's what an executive order is. And they're not new. They've been issued throughout our country's history. All the way back to President George Washington, we saw orders being issued. Most of them are directed internally at internal government affairs or at government officials. And they don't have a direct impact on external actors, on private individuals. A good example of that, when President Clinton entered office, President Clinton signed an order that put into place various ethics standards to govern his political appointees. And President Trump recently signed a very similar ethics order that also put into place ethics standards to govern his executive officers. So these kinds of orders that govern and speak to executive officials and their actions, they're really commonplace. And for the most part, they're not terribly controversial. But much more controversial are those orders that do have an impact on private individuals' lives, orders whose impact spills over into the private sphere. One particularly controversial example, a good example, I think, of such an order are memos that were issued during the Obama administration in the immigration arena. Memos that tried to protect undocumented parents and children from deportation. Another example of something more on the controversial side is the travel ban that Lisa, you just mentioned. And so another piece of your question, Lisa, was not just what executive orders are, but what gives the president the power to issue these orders that can have such significant impact on people's lives with just the stroke of a pen? The answer, I guess not that surprisingly, as it often is in the law, is it depends. Sometimes it's the Constitution that gives the president that power. And sometimes it's Congress via statutory delegations of power, where Congress hands away power to the president. But regardless, our president in our country is not a kid, right? He doesn't have a magic make it happen wand. Instead, all in some sort of legal authority, flowing from the Constitution or flowing from statutes. And
So are you saying that the president can, in effect, change the law simply by signing a piece of paper?
yeah, yes. In effect, even though I just told you the legislative branch is the branch that makes law, the president can make law too when he's been given the power to do that, when Congress has handed him that power, or when the Constitution vests that type of power in the president. To make it a little bit more concrete, maybe I could mention briefly 3 concrete examples of orders that President Trump has signed and show you how they'll have different effects. And the reason they have different effects is because of the legal authority that many of them are based on. So the 3 that I think would be good examples. First, the order that directs the building of a wall. Second, an order that tells agencies that for every new regulation they want to come in the door and be put on the books, they need to take 2 existing regulations off the books. And then the third contrast briefly about the first, President's order directing the building of a border wall. So does commit our country to building a wall along the entire border between the United States and Mexico, which spans nearly 2,000 miles? No, he really doesn't. And why not? Why doesn't he have that power? Well, because building a wall along the whole border would cost a whole lot of money. Estimates show somewhere between $8 billion and $25 billion. And under our Constitution, the president does not control the purse strings. Who does? Congress controls the purse strings. So years ago, Congress did pass a statute that authorized the building of some barriers along small portions of the border. But if the president wants to build a wall along the entire border, then the president's going to need money, and will need money from Congress. Now, President Trump and his advisors, they certainly know this. So as a result, if you read the order, then you'll see that what it actually directs, it simply directs government officials to try their best to identify funding, to find money, and to develop budget requests from Congress for money. So in the end, this particular order, its legal impact is fairly limited in terms of the wall, but it certainly has significant communicative value, communicating to his officers, telling them to start taking steps, and also significant political effect, because it sends a strong signal to his supporters that he is following up on a key campaign promise. Contrast that with President Trump's 2 out, 1 in order. This is an order that says to federal agencies that regulate everything from the environment, from the air we're all breathing right now, to safety of workplaces, tells federal agencies if you want to make a new regulation, then you need to take 2 existing regulations off the books. So this order will have significant effect on federal executive agencies. Why? Because the heads of those agencies, they work for the president. They can be fired by the president. So they listen to the president. But does the order itself actually undo regulations that protect me and protect you and that impose obligations on all of us and impose obligations on businesses? No, the executive order itself doesn't undo regulations, and it can't undo the regulations. Rather, under law, by the agencies, and it has to be done through a real process, one that we call notice and comment rulemaking. Sounds fancy, but really all it is a process that says all of us, everyone, has an opportunity to submit comments, to participate, and then the agency has to justify its decision based on the statute, based on regulatory scheme, based on scientific data, based on studies, and based on public comments. So in the end, the two out, 1 in order, it too doesn't have a huge amount of immediate legal impact. Sure, it has political value, communicative value. It tells its officers to start the process of undoing regulations, but the order itself doesn't undo regulations because the president doesn't have the power to do that. The law puts that power elsewhere. Now contrast that example with the third, the travel ban. The travel ban, which bans travelers coming from 7 predominantly Muslim countries, it obviously had immediate impact, significant impact, many would say severe impact on families, on children, people across the globe. It resulted in detention of individuals at airports across our country. So that order, it indeed did much more than simply issue directions. It actually altered rights. President Trump believes that both the Constitution and various statutes give him the power to take that action in the name of national security. Others believe that the president exceeded his powers and acted in violation of the Constitution. So not surprisingly, given this dispute, lawsuits have already emerged across our country, including one actually that was just filed here in Seattle on Monday by the state of Washington. State of Washington took the lead, quick to file, and we will see how that unfolds. A hearing is taking place on Friday. Also earlier this week, many of you probably saw it in the news, the acting Attorney General, Sally Yates, the head of the Department of Justice at the time, she was fired by President Trump, fired because she said that she would not defend the order in court. So given all the controversy, the legal controversy around this order, I expect that with time, these legal issues, they'll work their way up to the US Supreme Court, much as President Obama's actions in the immigration arena worked themselves up to the US Supreme Court last year. The issues of presidential power here, they're that big. So hopefully comparing and contrasting those 3 examples helps to show you that not all executive orders are created equal in terms of their impact. Some mainly serve as communication tools or political tools. Others have real legal impact on the ground that you see immediately. And as Lisa said, the reason for that, it's not random or haphazard, but rather it turns on the wording and the scope of the order, and even more importantly, on the legal authority that the president is hanging his hat on when he signs that order with the stroke of a pen.
Thank you, Catherine. Now, when it comes to whether the president has the legal authority to do things, sometimes the president disagrees with some other party or person in the government, and a lawsuit will arise out of that. And you mentioned that Washington has filed a lawsuit along those lines. Now, that brings up, for at least me, the question of the announcement that President Trump made yesterday when he nominated Neil Gorsuch to the United States Supreme Court. One thing that some folks may be wondering is if this judge is confirmed, will Judge Gorsuch, is he likely to just sign off on anything that President Trump does? For example, the travel ban?
Well, I don't have a crystal ball, so it's impossible to predict what Judge Gorsuch will or won't do with respect to, for example, the travel ban. But I can say that it's safe to say that Judge Gorsuch, just like other federal judges, they don't just do what the president says to do just because the president told them so, or just because the president appointed them. That's not how courts work. I remember watching a debate with my kids this fall, a presidential debate where Trump at the time said that if he were elected, Roe versus Wade involving abortion would be overturned automatically. And I remember explaining to my kids that that's not how it works. Presidents don't get to overrule Supreme Court precedents interpreting the Constitution. Only Supreme Court justices get to do that. And when they do that, when they interpret the Constitution, federal judges decide cases based on their interpretation of the law, not the whims of the presidential winds, not their own personal policy preferences. Instead, they have to act based on the rule of law. And I think really important here to keep in mind is that our Constitution does something, I think, quite brilliant. It insulates our federal judges. It gives them protection from politics. It gives them lifetime tenure, so job protection, and salary protections. And in giving them those protections, it enables them to act as an independent check on political actors. They can act as an independent check without fearing that removal, that being fired, that fear is hanging over their head. They don't have that fear hanging over their head, the same way that Sally Yates did when she stepped forward on Monday and said, I will not defend this order, and it resulted in her firing.
Great. So to be clear then, although a president, and here President Trump, nominates people to the courts, those judges and justices are then protected from the president at that point.
Yeah, that's right.
Okay. But of course, that's not true of many of the president's other appointments, including appointments of people to run a number of very important agencies, the State Department, the Department of Homeland Security, the Environmental Protection Agency. Those appointees generally serve at the pleasure of the president, which means that he has the power to fire them if he disagrees with something they are doing. Now, one of the most controversial of President Trump's recent appointments has been that of Jeff Sessions to run the Department of Justice. Trevor, as our expert on criminal law, what does the Department of Justice do? And can you explain why this particular appointment has been so controversial?
Sure. So let me start with a brief description of the Department of Justice. As many of you know, the Department of Justice, also known as DOJ, is a federal agency. It's principally charged with investigating and prosecuting violations of federal law. The Department of Justice has about 60 subdivisions, including the Drug Enforcement Agency, the DEA, the FBI, the U.S. Attorney's Office, and the Civil Rights Division. Now, the second question is a bit more complicated, speaking specifically about the controversy around Senator Sessions' appointment or nomination. It might be helpful to start by talking about the support for Senator Sessions. He is a longtime senator from Alabama. He served in that capacity for several decades. He ran unopposed in Alabama in 2014. He has a long track record of public service. He used to be the U.S. Attorney for the Southern District of Alabama. And returning to the controversial elements of his nomination, a lot of people have questioned his ability to relate to minority populations, his policies, his stances with respect to minority populations. What am I talking about specifically? If we go all the way back to Senator Sessions' tenure as U.S. Attorney for the Southern District of Alabama, he took a number of controversial positions with respect to voting rights. He specifically prosecuted 3 civil rights workers in 1986. And that prosecution has sort of dogged Senator Sessions' career for several decades. I just want to give you a few details about that prosecution. One of the civil rights workers, one of the 3, had been working for decades to register African-American voters in Alabama. The 3 of them were accused of voter fraud, mail fraud. There were 29 counts to the indictment. They went to trial. Many of the counts were thrown out by the judge at trial. The remainder went to the jury, and all 3 were acquitted. Senator Sessions says that if he was to go back, if he could turn back the clock, that he would again prosecute each of these individuals, and that's been very concerning to his critics. Let's fast forward to the contemporary context. Why is Senator Sessions a controversial candidate today? What has he done as senator to give people pause? Well, for one, Senator Sessions has advocated for eliminating police misconduct investigations by the Department of Justice. Senator Sessions has called these investigations disrespectful. He's called them offensive. And he says we're essentially, with these investigations by the Department of Justice, specifically the Civil Rights Division, undermining confidence in our police officers. I think President Trump sort of shares that general sentiment. He's essentially described critiques of police, these reform efforts at the federal and local levels, as being a part of a war on police. So again, that's concerning. There's an open question as to whether these pattern and practice investigations of police misconduct on the local level will continue in the Trump administration. If we're to talk about sort of the ability of Senator Sessions to eliminate or terminate these pattern and practice investigations and the consent decrees that stem from these pattern and practice investigations, it's going to be a little bit more difficult than I think he or his supporters suspect. For one thing, many of these investigations resulted in consent decrees. The Obama administration secured, I think it's 19 agreements at the local level with local governments with respect to criminal justice reform and local police departments. 14 of these 19 agreements were considered or are consent decrees in which a federal judge signed the decree, turning the decree from a mere agreement to a judicial order. So for those 14, with respect to those 14 consent decrees, there's really very little President Trump can do. The Department of Justice cannot sort of unilaterally terminate a judicial order. They can't unilaterally terminate these consent decrees. So I think we can have confidence that for people who support the consent decrees, who support these federal efforts at local criminal justice reform, we can have confidence that these agreements will remain in place. However, for cities like Baltimore, other cities around the country in which the investigations are open, in which the consent decrees have not yet been signed, I think it's very likely that the tentative agreements that have been forged will be terminated. I think it's also very likely that we will not, from this point forward, under the Trump administration, under Jeff Sessions' tenure at the DOJ, see additional investigations of local police departments that have been found to be violating local residents' civil rights in a systematic fashion. I want to put one more issue on the table, one more issue with respect to presidential power under a Trump administration, under Jeff Sessions' DOJ, and that's the issue of the federal marijuana prohibition. As many of you know, or some of you may know, Senator Sessions is not a fan of marijuana. He's made a number of remarkable statements about marijuana. Among other things, he said, well, back in his hearings back in the 1980s, he was nominated, to be a federal judge by Ronald Reagan. There were a number of witnesses who talked about racially charged statements he had made when he was operating in the Southern District of Alabama. But I think one of the more interesting comments that he was alleged to have made is that he was okay with the KKK until he found out they smoked marijuana. And that's testimony on the record in Senator Sessions' hearing. Now, he denies having made that statement, but he has made some curious statements about marijuana. He said in a Senate, I believe it was the Judiciary Committee, he said that in his estimation, good people do not smoke marijuana. And he's taken the Obama administration to task. By name, he's mentioned President Obama, he's mentioned Attorney Generals Loretta Lynch and Eric Holder, as well as FBI Director James Comey, saying they all have sort of abdicated their responsibilities as part of the executive branch specifically in enforcing marijuana decriminalization, in failing to enforce the federal marijuana prohibition in decriminalization states. So let me just wind down by saying that I do think the federal government, DOJ, Jeff Sessions, is going to be very aggressive about prosecuting marijuana production, distribution, and decriminalization states. And I think that's important. There will be a clash between the federal government and I think high-profile producers and distributors in decriminalization states. Let me sort of add a few points to that. This is not going to be an easy task for the federal government. Well, why is that? A couple things. One, it's important to note that the federal government does not have the ability to direct state and local police, right? It cannot issue directives, commands to state and local police. Well, why is that important? There are about 1.2 million law enforcement agents across the country. Only 80,000 of them are operating at the federal level. That means in order for the federal government to broadly enforce something like the federal marijuana prohibition, it needs the cooperation of state and local police. It often comes in on the back end after local police have made arrests for marijuana production, distribution, trafficking, and prosecutes. DOJ will prosecute on the back end. But, our local police are doing a lot of that work. So in the event that Sessions, the DOJ, does not have that cooperation, it's going to be, again, difficult for them to enforce the federal marijuana prohibition broadly in decriminalization states. So I want to make that point. I want to make the point that local governments still matter. They matter quite a bit in criminal enforcement, in federal criminal enforcement. And if local governments matter, that means local democracies matter. That means every person who participates in local governance matters, because you eventually dictate exactly what your police are going to be able to do, the extent to which they can participate in these criminal enforcement initiatives at the federal level. And I think that's important. And I'll add one last point. The idea of public safety, the concept of public safety and public security, is increasingly politically contested, right? For several decades, we sort of assumed that there was solidarity with respect to public security, public safety. That's no longer the case. If you look at immigrant sanctuary, if you look at marijuana decriminalization, local governments, local populations are increasingly rising up and offering their own sense of what public safety means, and as well as the means to public safety. And so I think we should also take that to heart as we consider our prospects for the next 4 to 8 years.
Thank you. So one thing I just wanted to underscore, it sounds like what you're saying is that even when we have a strong federal government, state and local governments still really matter.
They absolutely matter. They matter because the federal government, again, cannot control state and local police. They matter because state and local police outnumber federal law enforcement agents by a ratio of about 10 to 1. All of those elements, statistics, constitutional provisions, they're all relevant, and they make local populations, local governments, local democracies that much more important to federal criminal enforcement.
Thank you. So another place where we see this interplay between the federal government and state or local governments is is with respect to what are called sanctuary cities. So, Angelica, you're our expert in immigration law. Can you explain what is a sanctuary city? And is Seattle a sanctuary city?
I can try.
Thank you.
So there's no legally settled definition of what constitutes a sanctuary city, but the phrase has been used to refer to cities that take a very wide range of actions to protect immigrants that include declining to spend local resources, assisting with immigration enforcement, offering city services without respect to immigration status, refusing to detain immigrants for immigration officials, protecting confidential records, preventing local officials from asking about or investigating immigration status, and even providing access to legal counsel for immigrants facing deportation. So Seattle is taking several of these steps and considers itself, or at least seems to consider itself, a sanctuary city as of now.
And President Trump already has taken some steps to crack down on sanctuary cities. So can you help us understand, what can President Trump do to crack down on sanctuary cities, and how can he do it?
Sure. So first, it's important to point out that local jurisdictions have no legal obligation to assist with civil immigration enforcement, which is a responsibility of the federal government, not of local governments. So a local decision to offer resources to federal immigration enforcement is completely voluntary, and in some senses is actually lending local resources to what's really a federal government responsibility. So non-cooperation with the federal government in this case could be critiqued on policy grounds, but it's rarely a clear violation of federal law. In fact, the opposite has proven to be true. In terms of legal violations, many jails that have detained people and held them on the request of immigration authorities have been held liable for violating those people's constitutional rights. Nevertheless, of course, we saw in one of last week's executive orders the president threatening to cut funding for so-called sanctuary cities. However, the president's move to try to force local communities to carry out the work of federal immigration authorities is likely to violate principles, again, of local control, which say that the federal government cannot order cities around directly. Also, the threat to cut off the funding stands on pretty shaky legal ground. The same Supreme Court decisions that we saw on state and local power that red states relied to block democratic initiatives will be relied on now by sanctuary cities and states to try to block the Trump administration. So ironically, it's those decisions that might prove helpful now. If the Trump administration tries to withdraw money from cities for refusing to affirmatively help federal immigration authorities, that withdrawal of funds under current case law will have to be pretty limited in scope, and even then it might be unconstitutional. So as long as cities avoid affirmative interference with federal immigration enforcement activities, the national government will probably be quite limited in the amount of punishment it can dole out. One other limitation, of course, will be the financial one. So Catherine's already mentioned the cost of the wall and the difficulties of actually carrying that out because of the finances. If President Trump wanted to follow through with the sanctuary cities and other immigration-related orders he signed last Wednesday, it would require 150,000 prison beds to house immigrant detainees, and that's nearly 5 times as many as are currently available now. And the estimated cost alone for that would be about $8 billion.
So does all of this mean that individuals who are in the country illegally can't be deported as long as they're in Seattle?
No, definitely not. So first, it's important to understand that the simple fact of being undocumented under the immigration law means you're subject to being placed in deportation proceedings, and that many Seattle residents are already actively facing deportation proceedings just about a mile away from here in the immigration court here in Seattle. So the question is for those folks in Seattle who have not yet come to the attention of immigration authorities, even living in a city like Seattle, the protections for immigrants may not be sufficient from them to stop from being in deportation proceeding or stop from ending up in deportation proceedings. The Trump administration has very clear deportation goals that were laid out in one of last week's executive orders. The priority for deportation is purportedly quote-unquote criminals, but the executive order defines this category so broadly that, at least in my opinion, pretty much all of the 11 million or so undocumented people in the US are now a priority for deportation. So in a sense, there are no priorities because everyone is now a priority. So the question then becomes, how will undocumented people end up facing deportation? I see the executive orders of this past week as a signal to immigration officers on the ground that pretty much any tactics they want to pursue are now fair game. And so this new executive order saying that every undocumented person is a priority for deportation means that we're likely to see a broadening of immigration enforcement practices, some of which had already been abandoned. So for example, the workplace raids that the Obama administration had basically stopped are likely to return. And we'll see a ramping up of raids that have been ongoing throughout the Obama administration. So raids on people's homes and neighborhoods are likely to ramp up. And there may be limited things that city officials can do to stop ICE officers from going to people's homes or to their workplaces. But again, despite or maybe because of that, state and local governments will continue to be incredibly important if they wish to be a line of defense for immigrants. We already see this happening. So San Francisco already filed a lawsuit, perhaps preemptively suing the Trump administration for its threats against sanctuary cities. Los Angeles, we saw taking a different tack yesterday, and again, all of this is happening in real time, with its city council announcing that it's going to be decriminalizing street vending knowing that the misdemeanors that immigrants, street vendors get charged with can make them vulnerable to deportation. So they're taking a decriminalizing tack. And locally here, just this week, the Seattle City Council passed a welcoming city resolution, which among other things calls for the development of a strategy to create and fund a legal defense fund for those Seattleites who do end up facing deportation. So these innovative legal and policy strategies will be more important than ever.
Thank you. So we're starting to see a theme here, which is that the president has an enormous amount of power, but it's not limitless. And this becomes clear when we look to the role that state and local governments play. And it also becomes clear when we look to the role that Congress out in Washington, D.C. plays. As Catherine explained, for the president to act, he often needs Congress to go along with him. Now this brings us to Sally, our expert in healthcare law. And Sally has particular expertise in the ACA, which is also known as Obamacare. So Sally, let me ask you this. What the heck is going on with Obamacare?
What is going on with Obamacare? What's happening is that the Republican majority in Congress is having a very, very difficult time agreeing on a replacement for the Affordable Care Act. And the reasons are both political and practical. So the Republicans in Congress and the Trump administration have said that they will not pull the rug out from under the 20 million people who gained coverage in the past 3 years. And they promised to maintain the pre-existing condition protections. And they've promised to reduce healthcare costs that are borne by individuals and by families. And these are all really popular promises. They are also extremely tough to square with the commitment to reducing federal regulation, reducing federal spending, and turning to a more free market approach. Because the ACA is already a very conservative, very free market oriented approach. So it would probably be easier to meet these promises by moving towards more of a single payer Medicare type system, or towards actually like more regulation and more subsidies. So that said, there are proposals out there. And there are two prominent ones from Representative Paul Ryan, who's the Speaker of the House, and from Tom Price, who is the proposed nominee for Secretary of Human Services. So these two proposals and similar ones that are out there would have impacts throughout the healthcare system, including employer-provided insurance and also Medicare. But I thought I'd just talk for a couple of minutes about a handful of key provisions in these as they relate to Medicaid and to the marketplaces. So first, both these proposals would repeal the requirement that people have insurance, and they would repeal the requirement that big businesses provide it. Secondly, they would fundamentally change Medicaid. So they would cut back on or entirely eliminate the Medicaid expansion for working age, low-income people. And they would convert the entire program to either a block grant or a per capita cap, and with less federal funding. And in return, states would get flexibility, but what they would get flexibility to do realistically is to eliminate the entitlement to Medicaid, or cut back on who's covered, or time limits, or cut back on coverage. I mean, this is a really important deal. It's a very big deal. There are about 75 million people who are covered by Medicaid right now, and that includes some of our most vulnerable citizens. It includes low-income people over age 65 and low-income people with disabilities.
Okay, so I thought that was a pretty interesting discussion on the powers of the president. Interesting because of two reasons. Because it came from the perspective of law school scholars and students, teachers and students both. So I guess one point that comes across very strongly is that even though the president has wide powers under what he calls what is called executive orders. And what basically are these executive orders? They are communication tools to his team, to the various federal agencies that come under him, and to the officers that are operating under him, who are political appointees. One cannot deny that they are political appointees, but one must also remember that they are not political appointees only when we have a Republican government in power. They are political appointees when we have the Democrats in power as well. So if we say that President Trump is, for instance, choosing his people and putting in his people, and of course there was a huge discussion on how some of those people are controversial. We must remember that this is the same procedure that is followed by would have been followed by the Obama administration as well. So all administrations, all presidents take in their teams, okay? And the other thing that comes across is that while executive orders are something that the president can use, and he does use, Trump has used executive orders, as have previous presidents. So there are reasonable restrictions even on the effectivity of executive orders. And one of those restrictions is the way that the federal system in America is structured. Okay, so you got an example of how states have their own ways of making, sure that their interests are or their policies are, upheld. And so that kind of a working. So federalism, the working of American federalism itself is a check on the power of the president. The other thing is that even the Congress, one cannot strictly say that it limits, or the Congress as well as the judiciary, they have their own. We had yesterday discussed the concept of separation of powers. Okay. So therefore, we see how it functions even in the case of, affecting the president's powers, because the president does not have the power to overrule certain statutes that are passed by the Congress, or the power to overrule the pronouncements of the American judiciary. So we see that while the presidential system is centered on, let's say, the personality of the president, and the president is a very strong a mover in presidential systems, but in America the sense that we get is that democratic procedures are very strong, and the principle of separation of powers is very well entrenched, and that the judiciary also has considerable influence in deciding the you know the effectivity, the role. The president does not go unchallenged. If it can, and normally the impression that we get is that A, B, C president, could be Trump, could be Obama, could be Nixon, could be Reagan, could be anyone. We do get a sense that they may be all powerful and they may be unchallenged. However, we see that there are considerable restrictions placed on the working the the president cannot be whimsical, so there are no whims involved here. And probably the discussions that we see in the media are probably, they are more geared towards sensationalism or rhetoric. So therefore, to really understand the working of the American political system, we need to approach it with a very unbiased, very clear, very unrhetorical, very logical stand, and therefore we may be able to understand it in a more effective, in a more nuanced, in a more substantial manner. Okay. So in the next class, we have the please everybody please join in for the webinar tomorrow on time and promptly, and please do take notes. And I wish some of our webinars could be as crisp and as well structured as the thing that we saw today was. Anybody has any questions? Anybody has any observations to make? Otherwise, we can wrap up the class. There is time for observations. You can give your own observations also. We can stop the recording now and we can take observations. Kriti, please stop the
Yes,
recording.
ma'am, I'm stopping the recording.
So we can take observations from students as well.